The real 8-to-1 gun ruling everyone keeps vaguely referencing did not happen last week, and it did not expand gun rights the way a dozen recycled video titles keep implying. It happened in June of 2024. It is called United States versus Rahimi, and it actually upheld a gun restriction, not struck one down, a genuinely different outcome than what a title promising gun owners just won something big would lead you to expect. If you have seen a title promising an 8-to-1 vote that changed everything for gun owners, this is almost certainly the real case underneath it, dressed up with a fake urgency and, in some versions, the wrong direction entirely, borrowing a real, significant vote count and attaching it to a claim the actual opinion does not support. Let's walk through what the Supreme Court actually decided, with the real facts, the real vote, and the real reasoning. Because the accurate version of this story is genuinely significant, just not in the way the misleading titles suggest. And it happens to be more interesting once you understand what it actually says rather than a vague, inflated paraphrase of it. Quick thing before we get into it. I check dates, vote counts, and outcomes against the actual court opinion before anything goes in a script, not against whichever framing performs best regardless of accuracy. If that is useful, subscribe and turn on the bell. 2 seconds, and let's get into the real case. Start with who Zackey Rahimi actually is and how this case reached the Supreme Court, because the underlying facts matter enormously for understanding the ruling, and they are considerably more serious than a vague reference to a gun owner might suggest. In December of 2019, Rahimi assaulted his girlfriend in a parking lot in Texas, knocking her to the ground, dragging her back to his car, and banging her head against the dashboard. When a bystander witnessed the assault, Rahimi retrieved a gun and fired a shot at that bystander. His girlfriend subsequently obtained a civil protective order against him, an agreed order that included a specific judicial finding that Rahimi posed a credible threat to her physical safety, and the order explicitly warned him that possessing a firearm, while it remained in effect, could constitute a federal felony, meaning Rahimi had direct, written notice of exactly this legal consequence before anything else happened. Rahimi ignored that warning entirely. Over the following 2 months, he was involved in at least 5 separate shooting incidents, including firing at another driver after a car accident, firing at a constable's vehicle, and firing into the air at a Whataburger after a friend's credit card was declined, a pattern of escalating, genuinely dangerous behavior that the court's eventual opinion referenced directly when explaining why the underlying statute mattered in practice. Police, investigating those specific shootings, searched his home and found a rifle and a pistol, leading to federal charges under 18 U.S.C. Section 922 G8, the specific federal statute making it a felony for someone subject to this kind of domestic violence restraining order to possess a firearm. Rahimi pleaded guilty, but preserved his right to challenge the underlying law's constitutionality, a common procedural move that lets a defendant accept responsibility for the underlying conduct while still contesting whether the specific law they were charged under is even valid in the first place. His argument traced directly back to the Supreme Court's own 2022 ruling in Bruin, which established that a modern gun regulation must be consistent with the nation's historical tradition of firearm regulation, not simply serve a reasonable public safety purpose, a considerably higher bar than the standard many lower courts had applied for years before Bruin replaced it. The district court initially rejected his challenge, relying on pre-Bruin precedent that had already upheld this same statute for years without serious constitutional difficulty. The Fifth Circuit Court of Appeals, based in New Orleans, affirmed that decision on the same grounds. But after the Supreme Court's Bruin ruling came down, the Fifth Circuit reopened Rahimi's case specifically to apply that new historical tradition test, and this time reversed itself, striking down the federal domestic violence disarmament law as unconstitutional, reasoning that because early American legislatures had not specifically disarmed domestic abusers as a category, modern Congress could not do so either under Bruin's new, more demanding framework, a genuinely dramatic reversal from the same law that had survived constitutional scrutiny for decades before Bruin reshaped the entire legal landscape. The Supreme Court took the case specifically to resolve that exact question, and here is what it actually decided on June 21, 2024, by a vote of 8-1. Chief Justice John Roberts wrote the majority opinion, joined by every other justice except one, Justice Clarence Thomas, the author of the Bruin decision itself, who dissented alone, a genuinely notable detail worth sitting with. The justice who wrote the historical tradition test being the sole vote against how that same test got applied here. The court reversed the Fifth Circuit and upheld the federal statute, holding directly that when an individual has been found by a court to pose a credible threat to the physical safety of another person, that individual may be temporarily disarmed, consistent with the Second Amendment. That is the actual holding, in the court's own words, a considerably narrower and more specific proposition than a vague headline about gun rights being changed might suggest, tied specifically to an individualized judicial finding rather than any broad, categorical restriction untethered from an actual determination of dangerousness. Here is the historical reasoning behind that holding, because it matters both for understanding this case and for understanding how every major Second Amendment ruling since has built directly on it. The government needed to identify historical firearm regulations sharing the same underlying principle as the modern domestic violence disarmament law, not necessarily an identical law from centuries earlier, but something close enough in principle to establish a genuine tradition. Roberts's opinion pointed to two categories of founding-era laws. Surety laws required a person, found by a magistrate, to pose a threat of future violence, to post a bond as a condition of continuing to carry weapons publicly, a financial guarantee against future misconduct that functioned as an early, less severe precursor to modern disarmament. Going armed laws allowed authorities to disarm or imprison people who had used weapons to terrorize others, a more direct historical parallel to the modern statute's core concern. Together, the court concluded, these two historical categories, surety laws and going armed laws, established a sufficiently well-established tradition supporting the modern principle that someone found to pose a credible threat can be temporarily restricted from possessing firearms, even though neither historical law was an exact match for the modern statute in every specific detail. Differing in mechanism, in the specific procedures used, and in exactly what triggered the restriction in the first place, while still sharing the same core underlying principle the court identified as the actual test to satisfy. This is exactly where the ruling's language became genuinely important for every Second Amendment case that has followed it, including several major rulings just this year, and it is worth understanding as the single most consequential piece of this entire opinion, more consequential in the long run than the specific outcome for Rahimi himself. Roberts's opinion explicitly clarified that the government does not need to identify a historical twin, an old law matching the modern one in precise detail, only a well-established and representative historical analog sharing the same underlying principle. That clarification, historical analog rather than historical twin, is the exact legal standard the Supreme Court applied again this June in United States versus Hemani, the marijuana and gun rights case, where the government's own historical arguments were tested against this same standard and ultimately found wanting, and again in Wolford versus Lopez, the Hawaii carry case, where Hawaii's own historical examples, a Louisiana black code provision and an isolated Oregon poaching statute, were rejected as too narrow and regionally isolated to satisfy exactly this Rahimi-derived standard, both decided just this summer, 2 years after Rahimi first articulated the rule they were built on. Rahimi is not simply a historical footnote sitting quietly in the background of this year's bigger headlines. It is the direct doctrinal ancestor of the specific legal test the court has been applying in every major gun rights case handed down since, the actual analytical tool doing the work underneath this year's more heavily covered rulings. Now, let's address directly why a vague title promising this ruling changed everything for gun owners actually gets the substance backwards, at least in the sense most viewers would assume when they click on a title framed that way. This ruling did not expand what gun owners can do. It upheld an existing federal restriction, keeping firearms out of the hands of people a court has specifically found pose a credible threat to another person's safety, following a due process hearing where that determination was actually made with the affected person present and represented. If anything, this ruling represented a real test of whether the historical tradition test the court had just created in Bruin could actually sustain a restriction gun control advocates considered essential, one of the more commonly used federal tools for keeping firearms away from people already flagged by a court as dangerous, and the answer, 8-1, was a clear yes. It could, with only the author of Bruin itself dissenting from that specific application. Domestic violence prevention organizations, including Everytown for Gun Safety, describe the ruling as a matter of life and death for survivors, given how frequently firearm access factors into the most severe outcomes in domestic violence situations. A description considerably closer to the ruling's actual practical effect than any framing suggesting gun owners broadly gained new freedoms from this specific case. That said, there is a genuinely accurate version of Changed Everything worth understanding here, just aimed at the legal system and how gun cases get litigated generally, rather than at individual gun owners' day-to-day rights directly. This was the first major Second Amendment merits case the Supreme Court decided after Bruin, meaning it was the first real opportunity to see how workable Bruin's historical tradition test actually was in practice, applied to a real, high-stakes federal statute rather than left as pure academic theory debated in law review articles. The answer the court gave, clarifying that a historical analog is sufficient without requiring an exact historical twin, shaped how every lower court in the country has approached Second Amendment cases in the 2 years since, resolving a genuine, practical uncertainty that had been generating wildly inconsistent lower court rulings in the immediate aftermath of Bruin, and it directly shaped the reasoning in this year's biggest gun rights rulings. In that specific sense, Rahimi absolutely did change how gun law gets litigated nationally, just not in the direction or with the timing that a misleading "just happened" headline implies to anyone assuming this is breaking news from last week rather than a foundational case from 2 years ago. It is worth understanding the vote itself in a bit more detail too, because 8-1 with this specific lineup tells you something the bare number does not, and it is genuinely unusual for a case with this lopsided a bottom-line vote. 5 separate justices, Sotomayor, joined by Kagan, along with Gorsuch, Kavanaugh, Barrett, and Jackson, each wrote their own individual concurring opinions despite joining Roberts' majority opinion in full, meaning 6 justices total, Roberts plus these 5, all agreed on the outcome and the core reasoning. Yet 5 of them still felt the need to add their own separate written thoughts on top of the majority opinion they had already joined, a genuinely unusual level of separate writing for a case that was not actually close on the bottom line outcome at all. That pattern signals real, substantive disagreement about exactly how to apply the historical tradition test going forward, even among justices who agreed completely on how this specific case should come out. Disagreement about methodology and future application rather than about this particular defendant's specific situation. This is a nuance worth understanding on its own terms, which I will actually walk through in detail in a separate video specifically about those 5 concurrences, since each one stakes out a genuinely distinct position on how Bruin's test should actually work going forward and deserves real individual attention rather than a passing mention here, in an overview focused primarily on getting the basic facts of this case right. So here is the actual accurate summary of what United States versus Rahimi is, stripped of any misleading framing designed to make it sound like breaking news from last week, rather than a foundational ruling from 2 years ago. It is a real Supreme Court case decided in June of 2024, not recently. It upheld 8-1, a federal law disarming people found by a court to pose a credible threat to another person's safety through a domestic violence restraining order process, following an actual judicial finding rather than a blanket, automatic restriction. It did not expand what gun owners can generally do. It confirmed the government retains real authority to temporarily restrict firearm access from people found through actual due process to be dangerous to a specific person. And its lasting significance lies less in its direct holding for Zackey Rahimi himself and more in the specific legal standard it established, historical analog rather than historical twin, a standard that has directly shaped the reasoning in nearly every major Second Amendment ruling that has followed it, right up through this summer's biggest gun rights cases, Hemani and Wolford, both of which owe their entire analytical framework to the exact clarification Roberts wrote into this opinion 2 years earlier. Step back and consider why a real significant 2-year-old Supreme Court ruling ends up buried underneath a misleading, urgency-framed title in the first place, rather than being covered accurately on its own genuine merits. Rahimi is not a small or unimportant case. It is arguably one of the most consequential Second Amendment rulings of the post-Bruin era, specifically because of the legal standard it established, not despite it being over 2 years old at this point. But the Supreme Court clarified a specific evidentiary standard for historical analogies in Second Amendment cases does not generate the same immediate engagement as changed everything for gun owners, even though the first description is the accurate one and the second is not. A genuine mismatch between what actually makes a legal ruling significant and what makes a video title perform well. One worth remembering the next time you see a similarly dramatic claim attached to a vague or unnamed ruling. If this helped you understand the real case behind a title that got both the date and the direction wrong, hit like so it reaches other people trying to find the actual ruling instead of a vague, misleading reference to it, and subscribe if you have not, because I will keep tracing how Rahimi's specific legal standard continues showing up in every major gun case that follows it, including whatever the court decides next in this same ongoing line of cases. Tell me in the comments whether you had heard of this case under its actual name before today, because that tells me how much foundational context is worth building into videos like this one going forward, and whether the follow-up on the 5 separate concurrences is worth prioritizing next.